So once parties are set up and they start communicating with one another, they start looking into the other side of the story. So they do a little bit of fact-finding. What is, in your opinion, the importance of fact-finding?
I think you have to wind it back slightly. You have to remember what the mediation is all about and what the mediator is helping the parties to do. And what the mediator is helping the parties to do is to assess risk. So what they've got to do is to look at the risk of carrying on with the dispute, ending up in court and maybe getting an adverse judgment against the risk of settling. And you might be settling at the mediation for too little or paying too much. But in order to assess risk, you've got to have information. You've got to have the information, as much information as possible, in order to understand what the risk is. And you've got to also get clarification. You've got to understand the other side's case. Why are they saying what they're saying? You don't have to agree with it, but you definitely have to understand it in order to assess risk. And it's into that background that I think fact-finding fits. You've got to remember that as a mediator, you're not the judge. You're not there to make a decision. You don't need all the facts. You don't need to make a determination as to what actually happened, who said what to whom, who was doing something. And it may be that you won't find out at all during the day, because people's memories can be defective. I certainly can think of mediations where I've had people in the different rooms saying completely opposite things about facts. Now, there was no way I could determine what was right and what was wrong, but it didn't matter because we could move on, because what you can do is put that factual difference into what I call the risk bucket. And then they have to think about, well, which way is the judge going to find on those facts? But that said, it is important to clarify exactly what happened. And I think that what you do is you ask questions of the parties, and I think it's a very useful role for the mediator to play what I call the dumb mediator, to say, look, perhaps I'm being a bit slow here, but I just don't understand how this happened, or I just don't understand why you did this then. Surely I would have expected you to do something different. So tell me, why did you do this? What happened? And you get them to explain in their own words why something happened. And the other thing you have to do, because as you're working through all these facts, there tends to be lots of issues. I mean, sometimes I get mediations where I've had 3 or 4 lever arch files of papers. You know, you've got 1,000 pages that you've read before the mediation. And I say to the parties, I say, look, we're simply not going to have time to deal with all of this. We've got to prioritise what's important and what isn't. What is it that we need to focus on in order to bring this dispute to a conclusion? So there are 2 words I use a lot. One is prioritise, and the other is park. And I say, look, I know that's important. I know you've spent a lot of time, you might have spent a lot of money on it, and I can see that we may have to deal with it. But can we just park it for the moment? Because I think we're going to make more progress if we deal with these issues. And fortunately, some of these things that get parked then get left behind at the end of the mediation, and we never revisit them. But it's, I think, one of the roles that you have to do when you're in this fact-finding phase. You have to, you mustn't be judgmental about what's important and what isn't, because you don't really know at that stage. You might have a view, but as you talk to the parties and as you talk to their representatives, so something else that when you read the papers you thought, well, why have they spent time on that? I don't see that it's important. I think this is important. Suddenly, the importance of this other issue becomes apparent, and you realise that you have to deal with it.